Hello everyone, welcome to Courts Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting with an important update, the Securities and Exchange Board of India has banned industrialist Anil Ambani from the securities market for 5 years and has imposed a hefty penalty of 25 crores for diversion of funds of Reliance Home Finance Limited. SEBI has also barred Reliance Home Finance Limited and some of its connected entities and former officials from the capital markets for 5 years. Altogether, 27 entities have been levied penalties. The fine amounts have to be deposited within 45 days. SEBI found that during the financial years 2018-2019, RHFL was giving out large loans, each worth hundreds of crores of rupees, to unknown borrowers with very weak financial situations. These borrowers had little to no net worth, profits, assets or cash flow compared to huge amounts they were borrowing. RHFL often approved these loans without following the usual checks and processes. It turned out that all these borrowers and the companies they seemed to pass the money to were linked to the prompter group in some way. Later, RHFL also received guarantees for some of these loans from companies connected to the prompter group, further showing the link between them. SEBI found that Anil Ambani played a significant role in the activities of Reliance ADAG, particularly in connection with companies involved in scheme to divert RHFL's funds. Based on balance of probabilities, they concluded that Anil Ambani, the chairman of ADAG, was the mastermind behind the fraudulent scheme. Ambani has now been restrained from being associated with the securities market, including as a director or key managerial personnel in any listed company, holding of any listed company, or in any intermediary registered with SEBI for 5 years. We have been updating you about the developments in the RG Kar Hospital rape and murder case. You are also aware that a petition was filed earlier this week before the Calcutta High Court to investigate the ex-principal of the college, Sandip Ghosh. He has been accused of a number of illegal activities like mismanagement of dead bodies, misutilization of funds, and selling biomedical waste on the open market, etc. The petitioner had said that he had filed several complaints against Ghosh before the state authorities, but no action had been taken. He submitted that only after the unfortunate death of the doctor had the state constituted the SIT. Today, the High Court has transferred the SIT probe into the alleged irregularities to the Central Bureau of Investigation. A single bench of Justice Rajshri Bhardwaj passed the order today. CBI is also investigating Ghosh over the rape and murder of the resident doctor. The court today said that multiple agencies investigating similar facts may lead to delays and inefficiencies due to involvement of multiple parties. Therefore, it directed the probe be transferred to the CBI. Justices Suryakant and Ujjwal Bhuyan of the Supreme Court today heard Delhi Chief Minister Arvind Kejriwal's pleas challenging his arrest and seeking bail in the case registered by CBI over the alleged Delhi liquor policy scam. The hearing was today adjourned as Additional Solicitor General S.V. Raju, appearing for the investigation agency, sought time to file counter affidavit. Kejriwal has filed 2 petitions before the Supreme Court challenging the Delhi High Court's order of 5th August by which his plea against CBI arrest was dismissed. In one of these, the CBI has already filed its counter. It alleges that Kejriwal is trying to politically sensationalize the case before the court, although various courts have already passed orders being prima facie satisfied of there being commission of offences. I must tell you that in its counter affidavit, the CBI has said that all critical decisions in formulation of the excise policy were taken at Kejriwal's behest, and there is substantial evidence pointing to his involvement. It states that data retrieved from hard drives and mobile phones of co-accused have corroborated Kejriwal's connection to transactions and policy decisions in question. The matter will now be taken up on 5th September after the CBI has filed counter in the second petition also. In a significant development, the Supreme Court today held that Section 479 of Bharatiya Nagrik Suraksha Sanhita would apply retrospectively to the undertrials across the country. It means that the provision will apply to all undertrials in cases registered before 1st July 2024. BNSS replaces the Code of Criminal Procedure along with the other two new criminal laws. Though a procedural law, the BNSS applies prospectively, that is, to all the offences that take place after 1st July 2024. But now the Supreme Court has specifically allowed retrospective application of this one provision. So what is the Section 479 BNSS? The provision states that if a person is being held in jail while waiting for their trial, they can be released on bail if they have already spent half of the maximum time they could be sentenced for that crime in detention. The provisor to this section has now introduced a new rule, which is more lenient for first-time offenders. So if someone has never been convicted of a crime before, they can be released on bail if they have already spent 1/3 of the maximum possible sentence for the crime in jail. For example, if the maximum sentence is 6 years, a first-time offender can apply for bail after serving 2 years in detention. This is a change from the old rule under Section 436A of CPC, where they would have to wait half of the maximum sentence before being eligible for bail. The bench of Justices Hema Kohli and Sandip Mehta was hearing a PIL initiated to address the issue of overcrowding of prisoners in India, after the additional Solicitor General Aishwarya Bhati today said that Union of India was also of the view that the provision has to apply to any under trial who has completed up to 1/3 of the imprisonment and must be considered accordingly. The bench then called upon the superintendent of jails across the country where the accused persons are detained to process their applications through the concerned courts. The court added that the steps shall be taken as expeditiously as possible and preferably within 3 months. The top court has today granted anticipatory bail to the editor of Malayalam YouTube news channel, Marunadam Malayali, Shajan Skariah, in a criminal case under the SC/ST Act over making alleged derogatory remarks against MLA PV Srinijan. Skariah had telecasted a news item regarding the alleged maladministration of sports hostel by MLA Srinijan in his capacity as the chairman, District Sports Council. The Special Judge for Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act had denied him bail after prima facie finding that the allegations levelled by Skariah against Srijan were insulting and defamatory. The Kerala High Court had then dismissed his appeal against the same. So he approached the top court. Last year, while admitting Skariah's petition, the Supreme Court had granted him interim protection from arrest. Today, the bench said that the appeal of Skariah has succeeded and directed that in the event of his arrest in connection with the FIR in question, he shall be released on bail. After pronouncing the verdict, Justice Pardewala also said that the complainant may sue for defamation. A Delhi court today denied bail to 4 co-owners of a basement of the coaching center in city's old Rajendra Nagar area, where 3 civil service aspirants died by drowning earlier this month. The 3 aspirants died in a flooded basement at Rao's IS coaching center. The institute was illegally running a library in the basement where students got stuck in the flood. The Delhi High Court has recently ordered CBI to probe into the deaths. The Supreme Court, if you remember, has also initiated a suo motu case to ascertain the safety compliances of coaching centers in the national capital in wake of the drowning tragedy. In the next update, a Pune court has today dismissed the bail applications of all the accused in the infamous Pune Porsche hit-and-run case. The applicants were Shivani and Vishal, the parents of the teen who drove the Porsche car the night of the accident, Dr. Srihari Harnol and his 3 associates. According to the prosecution, the teenager drove negligently the Porsche car at a high speed and mowed down 2 individuals who were on a bike. Within hours of the accident, it is alleged that Vishal and Shivani paid 3 lakhs to Dr. Harnol, who was to take the blood samples of the teen to ascertain the alcohol levels in his blood. It is further alleged that after receiving the amount, the doctor resorted to tampering of evidence within hours of the accident. The court pointed out that though most of the evidence in the case is of documentary or electronic nature, it also includes statements of several witnesses, and there are full chances that the accused might try to win over the witnesses. Therefore, the court opined that granting bail at this stage would certainly lead to tampering of the evidence, which could result in denying justice to the victims, their family members, and also the society at large. In a significant development, a Delhi court has convicted Dr. Balwinder Kumar Sharma, the former Registrar Recruitment of the Punjab and Haryana High Court, along with 2 women in connection with the paper leak of Haryana Civil Services Judicial Branch Preliminary Examination 2017. The verdict was delivered by Principal District and Sessions Judge Anju Bajaj Chandana of the Rouse Avenue Courts. The court found that the prosecution successfully proved its case against Sharma and the other accused Sunita and Sushila through circumstantial evidence. Sharma and Sunita have been sentenced to 5 years in jail with fine of 1.5 lakhs and 60,000 rupees respectively. Sushila, the third accused, has been released, having already served the time during the trial. The court emphasized that paper leaks harm the integrity of public exams and stressed the need for stringent laws and long-term reforms to prevent such incidents in future. And lastly, the Kerala High Court has expressed concern over banks deducting loan installments from the relief funds deposited into accounts of Wayanad Landslide victims. These funds were provided through the Chief Minister's Distress Relief Fund. Hearing a suo motu case on disaster management, the division bench led by Justice A.K. Jayachandran Nambiar criticized the banks for appropriating these funds and emphasized the need for compassion and empathy in such situations. The court inquired about assistance given to the victims, restructuring of loans, and the possibility of writing off loans for those affected. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.